Good evening. It's my pleasure to welcome you here to Policy Exchange. If we've not met, my name's Richard Eakins. I teach law at Oxford, but I run Policy Exchange's Digital Power project with my colleague Graham G. And some of you will be familiar with our work, which aims to critically examine the rise of digital power in our governing arrangements here in the UK, and to outline a more limited account of its proper role. And you can find out more about our work, our various publications on our website. But let me commend you to a handful of recent work, if I may. Professor Timothy Intergott's paper, The Stubborn Staying Theory of Executive Power, from Magna Carta to Miller, available online. It's about as good an account of the executive power in our Constitution as I think you'll find anywhere. Sir Noel Malcolm's recent book, Human Rights and Political Wrongs, which is both a detailed critique of the European Court of Human Rights and its various works, and an original account of the nature of human rights. And we'll be discussing that here next Thursday evening with Nora O'Neill, John Finnis, Lord Phillips, and of course, Sir Noel himself. Our recent collection of essays, Judicial Power and the Left, which are a selection of brilliant left-leaning scholars, outline the old tradition of left-wing scepticism of judicial power. And finally, a book which is literally hot off the press, not quite hot, but arriving today, which is entitled Judicial Power and the Balance of Our Constitution. And that consists of two lectures by John Finnis, with commentary from 5 leading legal and political figures from throughout the Commonwealth world, one of whom is our lecturer this evening, the Honourable Dyson Heydon. And it's a great honour to introduce Mr. Heydon and to welcome him here to speak to us this evening. He is one of the common law world's foremost judicial figures. He served for 10 years on the High Court of Australia until 2013. Mr. Heydon was binarian scholar in Oxford. He served as law fellow at Keble College before returning to Sydney, where he was Professor of Law and then Dean of the faculty. Took up judicial office in 2000 in New South Wales and then moved to the High Court of Australia in 2003. He's made a notable contribution to Australian law, to legal thought throughout the Commonwealth. In addition to his judgments and his many dissents, which are always worth reading, his extrajudicial writings have been both insightful and entertaining. And they include his famous essay, which some of you will know, Judicial Activism and the Death of the Rule of Law, his article on whether Bills of Rights are necessary in the common law world, and his lecture on threats to judicial independence, The Enemy Within. And that's a theme that I hope we'll return to in a panel discussion we're holding here tomorrow at 1 p.m. with Mr. Heydon, as well as Lord Thomas, former Lord Chief Justice, Lord Falconer, the former Lord Chancellor, and others. And you're all, of course, very welcome to join us then. So, Mr. Heydon, it's a privilege to have you here this evening and to invite you to address us all.
Thank you very much, Professor Eakins. Ladies and gentlemen, it's a great honour to have been invited to deliver this lecture. The Judicial Power Project, I think, is a welcome initiative by Policy Exchange because the power of the courts in recent decades has expanded dramatically. The expansion has been accompanied by growing confidence on the part of at least some judges as to the topics on which they're competent to adjudicate. And that fuels still further growth in the jurisdiction. The phenomenon requires public debate and scrutiny. Supporters of the present role of the courts can only value, I think, reasoned and objective assessments of where things presently stand, if only to allow later developments to stand on a firmer footing. For potential critics of present trends, the Judicial Power Project can allow this silent revolution, which has been carried out largely without parliamentary sanction, to receive the attention and the scrutiny and the criticism that a substantial change of this kind deserves. What I propose to do is just examine first the court's development of their jurisdiction to effect judicial review, and then to consider some isolated exceptions to the general rule of the unchecked advance of judicial power, what you might call enclaves in a hostile province. One of those exceptions is Parliament's one of those exceptions relates to the so-called prerogative immunities possessed by the executive, that is to say, common law rights to behave in a certain way without any statutory backing for doing so. To those common law prerogatives, there is tending now to be pressure for them to be diluted or pushed in. Another matter which I'll deal with a little later concerns the position of members of Parliament. Historically, they have asserted considerable immunities to themselves. Both in England and Australia recently, there have been members of the legislature who get into trouble with the criminal law and attempt to rely on a privilege of that kind to escape its consequences by asserting that Parliament has exclusive control over their activity. Let me just begin by saying this, though. A critic might see the rise of judicial review as being simply an illustration of a very common judicial desire, and in many ways a healthy one. That is to increase the power of particular sectors of the judiciary at the expense of other institutions in the state. Those other institutions might be other courts, they might be the legislature, or they might be the executive. It's healthy because it has for a long time been a maxim that it's a good thing for a court to expand its jurisdiction. Trial judges, for example, enjoy expressing and relying on what they call their position of advantage, particularly in relation to questions of demeanour-based credibility. Intermediate appellate courts deprecate that preferred position. They stress instead the importance of achieving a correct result independently of any immunity which trial judges may enjoy against reversal. Intermediate appellate courts also stress the importance of arriving at correct conclusions of law based on their own earlier decisions or those of foreign ultimate appellate courts, whether or not the local ultimate appellate court has said anything to the contrary. Of this, of course, the leading exemplar was Lord Denning. For its part, the ultimate appellate court tends to strive to keep lower courts within their proper roles. A cynic might say that that simply reveals a certain institutional self-interest. Each level of the courts desires to increase its own jurisdiction at the expense of other levels and acts accordingly. But courts can also seek to increase their, what you might call their collective jurisdiction. In places where the courts can invalidate legislation as going beyond constitutional power, it's possible for the courts to move into a preeminent position compared with that of the legislature. And all courts sometimes act on Bishop Hoadley's perception that those with authority to interpret laws given by others are, by reason of that authority, the true lawgivers. This paper touches on a particular battlefield which has grown in significance in recent decades. The battle is between the courts and the executive. The courts have the power to weaken the executive in effect by compelling it to act within jurisdiction and by invalidating its conduct if it does not. I think if not the direct cause of this, a powerful factor in this was Chief Justice Marshall's assertion in Marbury and Madison that the courts had power to strike down statutes inconsistent with the United States Constitution. In other words, that the court had power to impose its view of the Constitution upon the other branches of government. Now, in Chief Justice Marshall's day, which was 215 years ago, that was far from being an inevitable conclusion. Even after Marbury and Madison, for decades, American state judges rejected equivalent powers under equivalent constitutional enactments. And even those judges who assumed powers that we would now call powers of judicial review conceived of their role in very different terms from their modern American counterparts, in that they deferred in large measure to the popular will, and they regarded judicial review as an exceptional expedient. The view of Marbury and Madison, the modern view of Marbury and Madison, which eventually prevailed, did face a powerful rival approach, which is articulated by James Bradley Thayer in the late 19th century. From 1811, there is evidence of the correctness of that approach, although there were precursors of it before that time. His approach did not deny that it was legitimate to conduct judicial review of legislation on constitutional grounds, but he did significantly qualify that legitimacy. In effect, he said that legislation should not be declared void unless there was no room for reasonable doubt about its constitutionality. That line of thought rested on the idea that while the judiciary had the primary role of decision on questions of law, the legislature had the role of initiating and enacting legislation. The question was not whether the courts thought that an act was unconstitutional. The question was rather what judgment the courts should allow to another department of government, which had been given the responsibility under the Constitution of enacting the relevant legislation. That approach of, in effect, giving the benefit of the doubt to the legislature and only overturning its legislation if there was no possible view on which its correctness, on which its constitutionality could be based. That approach has not been adopted in relation to judicial review of statutory constitutionality, either the act is within power or it's outside power. It doesn't matter whether on a reasonable view it might be thought to be within power. Something like that doctrine operates in American administrative law now, though it does not, on the other hand, operate in many common law jurisdictions as a matter of administrative law. For our present purposes, the importance of Marbury and Madison is this. It led to an increased status in American courts. It led to the extraordinary manipulative power that American courts exercise over wide areas of American life. And American conceptions of the importance of the courts have tended to influence their counterparts elsewhere. That is true of countries who have a written constitution, whether it's along the same lines as the American Constitution or not doesn't matter, but a written constitution which compels a decision on whether a statute is or isn't valid. But it also has led, I think, to judicial review in the wider sense, that is to say, judicial review of administrative action, of executive action. The adventure, really, which was embarked on in Marbury and Madison, at the end of which even Chief Justice Marshall couldn't foresee, led to the generation of sufficient energy to legitimise a strong extension of judicial review of administrative action. In English law, of course, it is, I think, trite to say that since Richard Baldwin in 1964, a revolution has taken place, both in regard to the decisions reviewable and in regard to questions like the standing to review them. And that has been paralleled by the modern importance of refugee law, law applying to those seeking asylum, to some extent to human rights law, to terrorism law, and to new substantive fields like environmental law. Some of those trends stem from the judiciary, others turn more on substantive statutory change. But almost all of these changes and increases in imperial power correspond with the particular interests of some segments of public opinion. I think we have to bear in mind that there is one dangerous factor in judicial review. Judicial review is intended to examine whether or not a member of the executive acted within statutory power or acted within common law power. The question of whether or not the decision was a meritorious or a correct one doesn't matter as long as there is power to make it. That is the strict approach. But in the course of reviewing the validity of the decision, the analyst often drifts into trying to work out whether it was the correct decision. In traditional administrative law, one of the grounds of intervention, of course, is the so-called Wednesbury doctrine, the doctrine that a decision will be set aside if it is so unreasonable that no reasonable decision maker could have made it. There is a natural human tendency to try and work out what a reasonable decision is, what I, the judge, think a reasonable decision would be. And having worked out that that is the reasonable decision, to conclude that there is no other possible reasonable decision. The position, therefore, I think in general is this. In previous times, there were various fields which were thought to be the subject of either legitimate discretion within the executive or as topics of political contest, which were ultimately controllable by the parliamentary questioning of ministers, the criticism of responsible ministers, the forced resignations of ministers, condemnation by the media of the public, votes of no confidence in Parliament leading to the fall of the government, and the outcome of consequential general elections. Those were those were consequences which were seen as appropriate to control certain types of executive misbehaviour. Those fields, though, now are starting to be regarded as legitimate areas for intervention by means of judicial review. That follows from a number of causes. Judicial review can be recognised and employed by opposition politicians to stall the programme of governments or embarrass governments. It can be employed by campaigners on a particular issue. It can be employed by those directly affected by government decisions. The last category, of course, are the people for whom the facility exists, but they tend not to be the only category now. There is another factor, I think, in the growth of the judicial function, and in particular the growth of judicial review. It's not simply a question of the tactics of litigants or the explicit conferring of powers on the courts. No doubt, people have always been cynical about elected representatives, but I think the present time is a time of increased cynicism about elected representatives and about the capacity of the political process to produce efficient results. Politicians are seen as self-interested, feeble, sometimes corrupt, and basically intellectually dishonest. Even when their policies are adopted by reference to public opinion, the policies tend to be tarred by the same brush. The public despises the untidy and even sordid compromises which are necessary to make the legislative process work. The courts, therefore, are perceived, and some courts perceive themselves as being outside politics or above politics, and as being capable of reviewing the complex policy decisions of government by reference to objective criteria. If you look at affairs in India, you see there an extreme version of the reaction against an unsatisfactory political class. The courts have taken an approach of having a sweeping policy oversight and responsibility. The Supreme Court of India goes out and tries to notice problems and make positive orders that responsible people fix those problems. There tends to be a gap between the people who are actually concerned with starting litigation to improve their lot in life and the court's capacity to ride that piece of litigation into new fields as the court sees fit. Now, things aren't like that here or in most parts of the common law, but it is true, I think, that there is throughout the common law world a tendency to see the court as a kind of balm or salve for the sore created by the ineffectiveness of the political process. Now let me just start with some basic propositions. The Crown or the Executive can be said to have three kinds of power. The first is power conferred by legislation, and there is of course a vast amount of that. The second is power conferred by the common law. The powers in that second category are often called prerogative powers. Traditionally, they were thought to be immune from judicial review, and that immunity is now under growing challenge. The third category of powers on which the executive can rely are the powers which the Crown, as a legal person, shares with any other legal person. For example, the power to enter contracts, subject to there being, if money is needed, subject to the money being appropriated by Parliament, then the Crown is usually thought to have power to contract. There was a dispute between Dyson and Blackstone as to this tripartite taxonomy. Dyson considered that there was no barrier between the second and the third categories. He saw the prerogative simply as being the residue in the hands of the Crown of all the powers which hadn't been taken away from it by the legislature. Blackstone, on the other hand, thought that the true prerogative powers, the second class I mentioned, were those unique to the Crown and were not shared with other persons. So for him, you had to have a third class of powers that were shared by other persons. Each of Dicey's view and Blackstone's view has judicial support. But what I want to just note now is the second category. Sometimes in that second category there is separated out a distinct subcategory. It includes powers to summon, prorogue and dissolve Parliament, to assent to bills and appoint members and judges. To appoint ministers and judges. Sometimes those powers are located in constitutions or statutes, in which case they fall outside the second category. And that type of power I just discussed have not attracted challenge to anything like the same extent as the other powers in the second category. The examples of the balance of that second category are things like the power to institute criminal proceedings by ex officio indictment, or the power to terminate criminal proceedings by entering a nolle prosequi, or the prerogative of mercy, the prerogative to make treaties and conduct foreign affairs, the prerogative to control the use of the armed forces, the power to consent to relator proceedings, and the power to grant honours. Now, the significance of some of these powers, of course, varies very greatly from instance to instance, but that is an area in which it was thought there was almost complete immunity, and in which it now can be seen, I think, that there isn't nearly so secure an immunity. In the mid-1980s, the House of Lords decided that the mere fact that the executive was relying on a common law prerogative did not of itself give it immunity from judicial review. What instead was decided was, this is the Council of Civil Service Unions case. Instead it was decided that there may very well be immunity in all the traditional instances, but that immunity will not be based merely on the prerogative. It will be based on the fact that there is some aspect of the relevant subject matter which makes it right that there should be an immunity, or there might be some disparity in the skills and capacities of ministers or members of the executive as compared to the courts, and so on. Now, there were arguments advanced to justify the old view that the mere existence of prerogative gave immunity. One was that there was a sufficient check on the abuse of executive power in the individual responsibility of ministers to Parliament and the collective responsibility of the ministry to Parliament. Another view was that the King could do no wrong. Another, in the words of Sir Owen Dixon, was that the councils of the Crown are secret. There are other justifications, namely that the prerogatives often involve matters of political judgment or relate to a particular subject matter, justifying immunity, or are different from statutory executive powers in that if the power rests in a statute, you can by construction work out what the scope of the statute is, what the criteria are which the statute requires to be satisfied before the power can be exercised, and in general you can work out what the purpose of the power is from the statute. If you are talking about a common law prerogative power, of course, on one view it's not so easy. There will be no express words telling you what the limits and relevant criteria are, and it may be difficult to work out in any other way for those limits are. Now, that last group of justifications I mentioned, political judgment, particular subject matter, and so forth, those arguments have tended to survive as grounds for conferring immunity to particular prerogatives, or, in a weakened fallback version, for exercising restraint in reviewing the exercise of the powers. The others, the king can do no wrong, the counsels of the crown are secret, that type of reasoning, have not survived, and that fate parallels the rejection of equivalent arguments in cases involving the review of statute-based powers. Now, the consequence of the overturn of the view that prerogative decisions were immune, and the perception that some of the arguments used to justify that outcome are empty, has meant that the prospects of judicial review are now greater than they were before in relation to the prerogatives. There have been certain spheres of executive activity which were traditionally thought to be beyond judicial review, and they can be viewed as islands of executive power, or they can be viewed as enclaves, if you like, in a judicial province. The judges rule the province of judicial review of administrative action, but they don't rule the whole of the province. There are little islands of immunity within that province. One of those islands, and in a sense quite a large island, is the island occupied by the power of the executive to conduct foreign affairs, to conduct defence, and to conduct intelligence work. In 1971, Lord Denning, in dismissing Raymond Blackburn's application for an injunction to restrain the accession of the United Kingdom to the Treaty of Rome, and the history would have been very different, of course, if that injunction had been granted. He did so on the ground that an exercise of the prerogative power of the Crown to make treaties, quote, cannot be challenged or questioned in these courts, period. And in 1985, Lord Roskill said, the courts are not the place wherein to determine whether a treaty should be concluded or the armed forces disposed of in a particular manner. Those statements unquestionably reflected the traditional received conventional wisdom. You can see some simple illustrations of the deference, if you like, of the courts to the executive by considering the following examples. On the question of whether a particular entity is a sovereign state and who the ruler of that state is, those are questions traditionally determined conclusively by a statement or a certificate from the relevant minister. It was not open to the parties to call evidence or to try and present argument to the contrary. The same sort of regime applied on other issues. Has the country and the forum recognised a foreign state? What are the boundaries of the foreign state? What are the dominions of the foreign state? What is the extent of foreign territorial waters? Is there a state of war between the foreign state and another state? Those are all matters to be decided, in quotation marks, by the receipt by the court of a certificate stating what the position was. Then you could have it moving away from those more formal diplomatic related questions. If you wanted to know whether goods which the government wanted to requisition were urgently required for use in connection with the defence of the realm, or the prosecution of a war, or other matters involving national security, he did so by getting a certificate from a relevant minister to that effect. And Lord Parker, in the Zamora, said that the statements of ministers on the matter should be treated as, quote, conclusive of the fact, in other words, incapable of being contradicted. In modern times, a less absolute approach has been taken, and it tends to illustrate a weakening in the former immunities. Lord Justice Simon Brown said that the courts must give great weight to the views of the executive on matters of national security. So in determining the meaning of United Nations Security Council Resolution 1441, on the question of whether debate about that would be damaging to the national interest, he said that weight had to be given to the views of the executive. Now, of course, to give something weight, and even great weight, is quite different from treating it as conclusive. Similarly, when the issue was whether a formal request should be made by the British government to the United States government for the return of people detained at Guantanamo Bay, the views of an official that a formal request of that kind would be ineffective and counterproductive was, while not conclusive, very heavily relied on. On the other hand, you can see in cases of that kind occasional expressions of doubt about the reasoning of the ministers or the officials, or demonstrations of inconsistencies and contradictions in the government evidence. Those are signs of a sort of slow and silent change. It's like Fabianism, the inevitability of gradualness. You have little changes like that, which over time come to work a complete departure from the starting position. And a related change in recent decades is this. In the days of Lord Denning and even the days of Lord Roskill, who viewed foreign affairs as a field of absolute immunity from review, we now have, in particular cases, inquiries being conducted by the courts into whether the court ought to decline to reverse a decision because it is ill-equipped to do so, or whether the court regards itself as being sufficiently equipped to examine the matter, as it were, for itself on the merits. So inquiries go into questions like whether there can be a sensible scrutiny of the particular decision. And again, as time goes by, these departures from an absolute ban on an examination of the legal merits of the matter will come to alter the law considerably. In short, the chance of decisions being reviewed which were once held to be automatically immune is now greater. Whether or not the court will consider intervention will depend much more on the circumstances. Now, let us pause for a moment and go back to the traditional absolute immunity. What were the reasons why the conduct of foreign affairs and defence remained immune from judicial review? One reason which the courts repeatedly stressed was that the executive had much greater access than the courts did to useful experience and expertise. A related reason is that the executive had much better access to local knowledge of information specific to the particular problem. A related consideration was the complexity of the policy questions involved. And connected with that, there was a perception that a distinction is to be drawn between what you might call political decisions and decisions based on individual justice. The fundamental task of the courts, it's almost universal task, is to look at a list, a controversy between two parties, and examine their individual positions and apply the law to those positions. If you are talking, on the other hand, about the merits of recognising another government or providing information to another government or denying information to another government, there will be, it is said, factors of a political character to be taken into account. the court is not just concerned with the rights and wrongs of two individuals, they're concerned with the possible impact on the whole society, on the whole nation. Now, a reason similar to that has been employed in relation to defence questions, not just foreign policy questions. Decisions whether to declare war or to seek peace, or decisions about using the armed forces in war or using them in peace as a preparation for war, those are policy decisions or political decisions. Individual interests will certainly be affected as the government attempts to ensure the survival of the state, but the process of reasoning involving questions of policy is alien from the traditional function of the courts. And indeed, in the Burma Royal case, Lord Reid said that it was almost certainly true that if judges had control over the declaring and waging of war, it would probably do more harm than good. Another factor lying in the background of the whole reluctance to intervene is that international relations between states, necessarily involve a measure of compromise between the states, or attempts to get compromise between the states. Law, said Lord Sumption, is animated by a combination of abstract reasoning and moral value judgment, a heady mixture which seems a great deal more attractive and more honourable than messy compromises that are in practice required to maintain relations with foreign states. His short point, I suppose, is that if you endeavour to enter this messy world of compromise, you will probably prevent the executive making satisfactory compromises, and you probably won't greatly assist the litigants on whose behalf you are making that attempt. Lord Hoffman saw judicial reticence in relation to national security as turning not only on the greater expertise of politicians, but on the serious potential results of decisions affecting national security, and he therefore considered that some legitimacy had to be found to justify those decisions, and the legitimacy was to be found in the responsibility of politicians to the Parliament, and ultimately to the people. Judges alone could not fairly be expected to take responsibility for decisions of that kind. He saw security questions as concerning the interests of the entire realm, and also concerning the use of public funds, and those who have to safeguard those interests and spend public funds have to take into account a great many more factors than the court either can or is likely to be able effectively to do. Now, so much then for those common law prerogatives. The position, I think, is there has been no massive revolution. There is no single Donahue and Stevenson-like decision which reverses the whole body of law. Instead, there has been a repeated statement by the courts that the old conclusions of absolute immunity and the arguments that led to them aren't entirely satisfactory now, and the matter has to be looked at by case to case in light of particular circumstances. The other thing I want to do this evening is deal with the traditional privileges and prerogatives of Parliament to govern its internal affairs and proceedings. Now, Parliament has power to punish for contempt, and it can imprison people for that. Normally one thinks of power to imprison or the power to inflict criminal sanctions as something exclusively vested in the courts. Not so. Parliament also has power to impose sanctions on its members for misconduct in office, or at least the House of Commons does. Not all Westminster parliaments throughout the world have the full reach of the powers of the House of Commons. It's customary to use the phrase exclusive cognizance of this. Parliaments in the Westminster tradition have enjoyed exclusive cognizance in relation to their internal affairs, unless there is a statutory qualification to that, and unless there is a constitutional provision affecting that. And it's in effect a question of law as to whether there is a relevant parliamentary privilege, and the courts have power to determine the existence and extent of parliamentary privilege. One of the doctrines out of which exclusive cognizance is said to have arisen was the premise that Parliament was a high court and it had its own peculiar law which was not known to the ordinary king's courts. Now that premise, of course, is the product of another age. Incursions have been made upon the exclusive cognizance of Parliament through the laws of contract and tort. Neither Parliament nor its officers have any immunity from the law of contract if the contract is made and broken. The same is true if someone trips on a slippery floor in parliamentary premises. Now, what is the test, though, which marks out the area where there still is a parliamentary immunity, a parliamentary privilege, and there is not? The test in Canada was said to be narrow. The question was whether there was a privileged sphere of activity, and that required demonstration that the relevant matter is so closely and directly connected with the fulfilment by the Assembly or its members of their functions as a legislative and deliberative body, including the Assembly's work in holding the government to account, that outside interference would undermine the level of autonomy required to enable the Assembly and its members to do their work with dignity and efficiency. In the House of Lords, in Queen and Chater in 2011, the matter was examined and a similar conclusion was arrived at. Members of Parliament who were accused of misconduct in relation to allowances were not permitted immunity merely because they were members of Parliament and the allowances related to their remuneration. In Australia, there was a similar sort of case recently, which is interesting because of a spirited argument that was advanced on behalf of the accused. Concerned a man named Edward Moses Obeid. He was elected to the New South Wales Legislative Council, which is the upper house of the Parliament of New South Wales, and that happened in 1991. For 20 years he served there, and he served as the Minister for Fisheries from 1999 to 2003, a humble post. But his fame or his notoriety in New South Wales did not arise from his role as a minister. It arose because of his influence within the New South Wales branch of the Australian Labor Party and his dominant role in a leading faction of that party, or a sub-faction of the party's right faction, over the 20 years or so that he was in Parliament. As time went by, Mr. Obeid first fell from the ministry, and then he came under inquiry by a body called the Independent Commission Against Corruption, and it came to be noticed that he seemed to have many more assets than his parliamentary salary would justify, and eventually he was prosecuted on the charge of having committed a common law crime, namely willfully misconducting himself in a public office. The indictment charged that while he held public office as a member of the Legislative Council, he had made representations to a senior public servant in order to get an outcome which was favourable to his family and to his personal interests in some properties at Circular Quay, which is a sort of tourist place in Sydney. His lawyers contended that that was an impermissible infringement upon matters falling within the exclusive cognizance of Parliament. In effect, they contended that Parliament had jurisdiction to punish him for anything he'd done contrary to the law, but not ordinary courts. They raised those matters in an interlocutory application before the trial judge, and the trial judge refused their application. They appealed against that refusal to the Court of Criminal Appeal, and that was refused. So then the trial proceeded, and he was convicted and sentenced to 5 years imprisonment. And then he appealed again to the Court of Criminal Appeal, in effect rerunning that round. Query whether or not he should have been allowed to. Answer, he slightly modified his ground, as we'll see. Now, at first instance, in the first hearing before the trial judge, it was contended that misconduct as a member of the Legislative Council in the course of discharging his functions was a matter only for the Legislative Council. The trial judge rejected that, and he said that the powers and privileges of the Legislative Council were not equivalent to those of the House of Commons. In particular, he said the Legislative Council has power to expel members, but it doesn't have power to punish them criminally. He also said that the powers and privileges of the House of Commons did not go so far as OB's team asserted. Now, that second finding, of course, is of more than parochial interest. The trial judge relied extensively on the decision of the Supreme Court of the United Kingdom in the Queen and Chater. But in consequence, he held that the crime of willful misconduct in public office was not the discharge of a function incidental to the office of an MLC, and hence it was not a so-called ordinary crime, and hence it was not quintessentially a matter appropriate for the Legislative Council to determine. The trial judge said that the conduct of Mr. O'B did not affect the internal administration of the House. It didn't occur within the precincts of Parliament, didn't relate in any way to the legislative or deliberative processes of the House or its members. Now, when Mr. O'B was convicted and he brought his second appeal, as it were, at the Court of Appeal, he changed his, and I should say that the appeal from the trial judge failed, and it failed for the reasons basically given by the trial judge. He adjusted his arguments, though, in his second appeal to the Court of Criminal Appeal. He said what was involved wasn't a question of jurisdiction, which was the point of the first argument. Instead, it was a principle of non-intervention. He said the courts ought to adopt a principle of not intervening on matters that fall within the cognizance of the Legislative Council. He argued that a charge involving assessment of the standards and responsibilities and obligations of a member of Parliament would lie within the exclusive cognizance of Parliament and should be examined by reference to rules, regulations and informal protocols of Parliament governing those standards. Those contentions were rejected. The idea that there should be a self-denying ordinance was rejected. The idea that the civil courts should decline to exercise jurisdiction was rejected. Chief Justice Bathurst said that the courts should decline to exercise jurisdiction only within narrow and recognised exceptions into which Mr. O'B's case did not fall. Now, it is true, I think, that this is not an appealing case from the point of view of seeing it as a vehicle for examining the exclusivity of parliamentary power. I say that because Mr. O'B's conduct was a long, long way from the heart of parliamentary activity. But the arguments advanced by his counsel, which are too detailed to describe here, as to why the courts were an inappropriate forum for the adjudication of the offences in light of the historical privileges of Parliament, does deserve consideration. It does raise a question similar to some of the issues that cluster around the prerogatives discussed earlier, namely, what can the courts do safely and competently, and what is it that they cannot do safely and competently? We've seen in recent times old institutions tending to become segregated from their past. The Judicial Committee of the House of Lords was abolished. The office of the Lord Chancellor was not abolished, but its functions were greatly changed. And the composition and the functions of those institutions, which once blurred the boundaries between the exercise of executive and legislative and judicial power, have gone. But there is a factual aspect of segregation as well. There was once a well-trodden route from the bar to politics to judicial office. Now there is a segregation of the practice of politics from the practice of the law. It was once common for barristers to retain busy practices while simultaneously serving as members of parliament, but that has become extremely rare. Parliaments and other democratic assemblies are increasingly populated by those who have chosen politics not as a vocation, but as a full-time career. There have been, of course, tough politicians who ended up in ultimate appellate courts. Almost all the pre-2005 Lord Chancellors, Rufus Isaacs, the first 5 members of the High Court and quite a number thereafter, Charles Evans Hughes in the United States, and John Marshall himself. But in the United Kingdom, in the United States, in Australia, and elsewhere in the Commonwealth world, appointments of politicians to the courts have become increasingly uncommon, and they seem to have ceased entirely in some final appellate courts. That is significant, I think, because unlike judges of an earlier era, contemporary judges are unlikely to have run for office or to have experienced extensive contact with constituents or lobbyists, or to have been involved firsthand in policy formation. Yet to an extent unmatched by their predecessors, modern judges have assumed for themselves, sometimes almost as sleepwalkers by degrees, a jurisdiction inquiring into how nations are run and ought to be run, how civil servants make decisions and ought to make decisions, and how elected officials comport or ought to comport themselves. And they have done so in spite and possibly even as a result of their own insulation from such matters over the course of their careers. These recent expansions of jurisdiction, which are connected with the prerogative immunities, stem, I think, from a measure of judicial self-confidence. It might be asked whether that is warranted. Judges can certainly hold strong personal views on matters of policy, broadly defined. That is simply because they're intelligent citizens. They can have their own opinions on how nations should relate to each other and on how members of the legislature should exercise their functions. But those personal opinions are not necessarily accompanied by any special experience or competence, which is relevant to weighing one policy consideration against another, or to determining which ideals are capable of translation into policy and which should remain at the level of aspiration. The career of Mr. O'B raises the question whether parliamentary procedures, parliamentary debate, and interactions of parliamentarians with those who elect them render legislatures better equipped to examine those issues than courts. Of course, obviously, legislative trials and punishments can be extremely unjust. When the Long Parliament found that it lacked the evidence to justify passing an act impeaching Thomas Wentworth, the first Earl of Strafford, it simply passed an act of attainder for which evidence was not required in order to secure his death. And legislative inaction can be equally unattractive. It can leave crimes committed by politicians less punished than crimes committed by non-politicians. A party which has a large and tightly whipped parliamentary majority could unjustly pick off its enemies or protect its friends, not on the merits, but by the mere weight of numbers. In contrast, courts are obviously not biased. Courts also are skilled in applying the traditional protections of a criminal trial. Their proceedings are likely to be much fairer than any legislative witch hunt. And legislative inaction may stem not from an informed judgment, but from a sort of dog doesn't bite dog mentality. On the other hand, decisions to proceed against an alleged wrongdoer can depend on value judgments underlying the question, how should politicians conduct themselves in public life? The failure by Parliament to pursue alleged offenders may reflect a recognition that the matter is best addressed by the people. The people can take up the opportunity afforded by the next election to drive from office those politicians who fall short of ethical standards in public life, and the people can vote for those of greater virtue. Now, should the court's exercise of their concurrent criminal jurisdiction give due regard to the choices of Parliament in that respect, having regard perhaps to the legislature's greater competence to resolve the issues, should there be a self-denying ordinance of the character urged by counsel in the agreed proceedings? Since an appeal by Mr. O'B to the High Court of Australia remains pending, it would not, I think, be right to offer dogmatic answers to those questions now. But the arguments devised by his counsel, perhaps tailored to more borderline circumstances, do provoke thought.
We have time for a handful of questions. So if anyone wishes to ask a question, raise your hand, catch my eye, and we will pass the microphone around. So there's one here. Yes, you want to say who you are? And another. Proceed. We'll take another group of three, I think. So.
What about once it's changed? To the extent that the courts change their role, and the wider community may have reservations about the evolution of behaviour of courts, how in practice, and I'm thinking particularly in relation to the United Kingdom, do you think going forward Parliament and politicians may be able to affect remedies to constrain the behaviour of courts, and should they examine some of the legislation passed in the 1970s as part of that?
So our second question is Sir Stephen Laws, just here.
Yes, I'm Stephen Laws. I'm former First Parliamentary Counsel. I was very interested. I thank you for that masterly analysis, and I fully agree with a lot of what you said, particularly about the social separation of the courts and the Parliament. But I wanted to ask in particular, because you dealt with parliamentary privilege in terms of members and their behaviour, I wanted to ask in particular about the implications of Article 9 in UK terms of the Bill of Rights and the rule that proceedings in Parliament shouldn't be called into question in any court. Because it seems to me in dealing with the executive enclave and the parliamentary enclave, that there is an isthmus between the two, which is that if you encroach on the executive enclave, you necessarily encroach on Parliament's enclave, because you get to the situation where the courts are second-guessing parliamentary accountability. And it's like to say this, you know, some members of the audience, but in some ways, Miller is an example of this. Here was a case where the case was presented as a challenge to executive power, but in fact, in substance, what the applicants were after was to try and change proceedings in Parliament. They wanted to change the way that the government's policy was held to account. And so there is a link between the executive enclave and the parliamentary enclave.
Third question.
Sebastian Kornhausen, UCL. Brilliant speech, thank you. Although there is an issue as to the separation of powers, which lines of demarcation are not clearly delineated, I would have thought the case of Alice Minnick versus the Foreign Compensation Commission would have supported your argument as to what is ultra-virus and what is ultra-virus. Thank you.
Well, the first question essentially was, how can Parliament react to judicial intrusion into former immunities? The immunities I'm talking about are common law powers, so they could be controlled by sufficiently clearly expressed legislation. Of course, the enactment of legislation which restricts judicial power is generally not popular. It tends, I think, the department as a whole, to use most in relation to claimants for asylum. But leaving that field, rather special field on one side, it's not a popular course for a government to absolutely shut off judicial review. A less unpopular course perhaps is to control it. It can be done by very short limitation periods, possibly by limitation on appeals. That is, it can be done. I'm not sure if I got the second question entirely clearly, but the existence of Article 9 doesn't stop, of course, courts dealing with parliamentary proceedings that resulted in the enactment of statutes. There's nothing wrong with the court construing a statute, seeing whether officials acted within power or outside power. Nor is there anything, I think, wrong with moderate criticism of the statute from the point of view of achieving some law reform. I mean, several hundred pages of vituperation are one thing, but some moderate, courteous, and concrete suggestions for improvement couldn't interfere with Article 9. I might have to speak to you later and penetrate more deeply into your question. As to the third one, yes, I agree with what you said about it.
Another question here. Take a last one.
Oh, sorry.
No, that's all right. No. You caught my eye. Take care.
Hello.
There's a microphone too. That's right.
Eve Samson. I was very interested in the Abate case and the extent to which the privilege argument was run, given that repeated reports from UK parliamentary committees have limited the immunities, parliamentary immunities, very clearly to matters which are directly connected with proceedings in Parliament. There's a string of parliamentary reports basically saying that privilege shouldn't apply to matters such as that, such as that for Mr. Abate. And the thing that I remember is in the Chater case, what the court specifically called the House Authority's clamant silence on the matter of whether privilege applied.
I think Mr. Abede's legal advisors were very cross with the Legislative Council. They wanted a sort of bit of energy zip for the Legislative Council saying this is an intolerable interference with our privilege, please stop. But there was no such noise. There was a deafening silence, as it were, there too. Without to impugn unduly the chances of success for Mr. Abede in the High Court, I think there's no doubt it was generally thought that the prosecution had a very strong case. His only chance was some rather technical point of the type he ran. It's unfortunate for him that the facts were so far away from where the Legislative Council is in Sydney that it didn't mesh him too well. But I'm commending the arguments advanced on his behalf as a matter of respecting the skill of the author and saying that it may be that there are Abedes in future who are nearer the borderline and those arguments might help. That's why I raised it.
I think it just remains for me to invite Lord Justice Sales to deliver a vote of thanks on our behalf.
Good evening. As a member of the English judiciary, I'm in a position to say how very highly regarded Dyson Heydon is as a judge, not just in Australia, but in this jurisdiction as well. His opinions are read with admiration here by our judges. Lord Dyson, the previous Master of the Rolls, personally recommended that I read a very important article that Dyson Heydon had written on judicial independence, and that's how highly his views are regarded here. It's been a most thought-provoking presentation, and just three thoughts in which it provoked in me to mention, just to bring out how fruitful I thought the analysis was. First of all, I think it is very helpful and illuminating to look at the conjunction of political accountability mechanisms alongside legal accountability mechanisms, particularly by way of judicial review. The system has an overall way in which it works, and I found it really illuminating the way in which Dyson Heydon brought that out. I think that there is a subtext in the development of judicial review, which is based on a degree of public cynicism about politicians. I would add that at some level, I think there's a sense of a disconnect in the political sphere between the politicians and the often apparently uninterested electorate, where sometimes the courts feel that they're being tempted to fill that void. Secondly, I think that one can perceive a certain development of a culture of justification, which is expected by the courts, as counterposed to a culture of authority, which was very much the approach, say, 50 or 60 years ago in the field of public law. But of course, that begs questions about how far justification ought to extend or can reasonably expected from political organs. And often it may be said that the courts lose sight of the messiness of the politics of compromise and the value of messy compromise, another theme which Dyson Heydon, I think, quite rightly pointed to. And the last thing that really struck a chord with me, and to echo very much Stephen Law's as well, I think that there is an underlying problem, if you can put it this way, of the segregation between the practice of law and the practice of politics. This has actually been quite a long-term process, which is has become more acute as time goes by. The effect is subtly to undermine the understanding on both sides of the divide, politics and law, of how the other works and what values the other gives effect to. And on the judicial legal side, it has some impact in undermining a sense of trust in the political process. In yesteryear, when leading judges were members of the legislature in their role as members of the House of Lords, they actually saw how legislation was made and the way in which the political process took account of a whole range of different factors and values. And sitting in the somewhat ivory tower of the courtroom, one loses that sense, which previously was acquired by almost a sense of a process of osmosis from senior judges being involved on both sides of the divide. So that, as I said, certainly struck a chord with me. So can I invite you all to thank Dyson Heydon once again for his most thought-provoking lecture.